You can now visit our website www.fanzonett.com for your authentic wear and collectibles. The only place where you can use both your Visa debit and credit cards. Visit our website fanzonett.com to make your purchase today.
Transform your home with PCU Plus. From stylish furniture to the latest appliances, we have everything you need to create your perfect space. At PCU Plus, we offer fair prices and affordable financing options that are cheaper than hire purchase agreements. With convenient locations in San Fernando, Tobago, Arima, and our lifestyle showroom in Barataria, you're never far from the best deals. Visit PCU Plus today and discover why we're the top choice for quality furniture and appliances. PCU Plus. Quality you trust, prices you'll love. Visit one of our locations or find us online to start transforming your home today.
This is Face of Sports, WESN Content Capital. How you felt about the kiss on the lip?
That's the business. I'm nothing to do with that.
I find that was distasteful.
The national senior team, whether you like it or not, that is the model for all other teams to follow.
I'm assuming that the regional requirement may be a much stricter requirement.
This is not about Pro League and Super League. This is a league run by the Normalization Committee that I'm responsible for.
Nobody expected FIFA to fund this arrangement.
If we don't get a professional attitude towards this, we are doomed for failure.
You break the balance, trip the leg, control the body.
They ain't gonna stand put forever.
Why you want the Chiefs to lose so? Why you want the Chiefs to lose so?
They already have two. Lamar don't
Why?
have.
You're jealous because you know the Chiefs getting closer to the Patriots. Let's go to the last part.
No.
Let's go to the last part.
Attention everyone, the Office of the Prime Minister Communications has launched a brand new WhatsApp channel designed to keep you informed and connected like never before. Get real-time updates, breaking news, and important information directly from the source. With our WhatsApp channel, you'll always know what's happening when it's happening. Joining is easy. Use your phone camera, scan this QR code, tap follow, and that's it. You're in. Be sure to tap the notification bell to never miss an update. Stay informed, stay empowered. Join the conversation with the Office of the Prime Minister Communications WhatsApp channel today.
WESN.
Hi. We on? I'm not hearing clearly.
I'm here. Are you hearing me?
Well, you're breaking up. Excuse me, you're breaking up a little bit. They were talking to me from the studio a moment ago, so I wasn't hearing you. You saying we're on?
Is it any better now?
Well, hello everybody. Welcome to the program. This is 10 Questions on this day. I'm Andy Johnson in here, and our guest again for the second week in a row, Farid Ali, prominent attorney in Port of Spain. We're talking about the law and justice. In the last program, we looked at the question of the presumption of innocence. No matter what you see and what you make of somebody being accused of a crime, particularly we're talking about capital punishment, and for that matter, matters going down from there. The question is to what extent somebody can be judged before the matter appears before court. In some cases, juries and judges, quite apart from below that, you have magistrates and other people, other officials of the law. We're looking at two particular cases this morning. One we call the Vindra Naipal Kuhlman case, and the other, the police officers who were on trial for the killing of a couple of people in the Muruga district. We want to start with the Israel Khan matter. In fact, in both cases, Mr. Khan was there. In one case, I think, can you correct me if I'm wrong, Farid, in one matter he was the defense attorney, and in the other matter he was the prosecutor?
He was the lead prosecutor in the Vindra Kuhlman Naipal matter, and he was the defense attorney in the Muruga murders, which is involving defending the 6 police officers who were arrested for the deaths of Alana Duncan, Abigail Johnson, and Karen Eccles.
Yeah, and it's interesting that in the case in which he was the defense attorney, those police officers walked free.
Yes, indeed. The police officers were charged, in my estimation, around October 2011 for the murders of Johnson, Eccles, and Duncan. And they were acquitted in November 2023, some 12 years after. So he was the defense attorney in that regard.
Right. And what do we make of the fact that in the other matter, in the Vindra Naipal Kuhlman case, this lady was abducted and killed, and some of the details of it, you don't want to necessarily go into it, because to what extent it's true, we don't know what happened to her body. But he was the
lead prosecutor.
The lead prosecutor in the matter. And a lot of people, a lot of store was put on the fact that if he were acting in such a position, then the judgment may have been different. But again, he lost that one as a prosecutor. And there were 9 young men who were, 7 or 9 of them who were on trial for that, and all of them walked free.
Yes. The thing with it is, you're only as guilty as the evidence says that you are. Like everything else, when there's an accusation involving murder, your reasoning as a police investigator, you're reasoning backwards, meaning that you have a dead person in front of you, but you're trying to ascertain what would have been the causes of the death. It's almost like you're doing a doctor diagnosing a cancer. He only sees you when it is the cancer manifests itself. He has to now go and examine you and try to investigate what he's seeing in terms of your history to determine what would have triggered this cancer in the first place. In the same way in a courtroom, what happens is all the parties come together, the defense, the prosecution states its case, meaning what the investigation revealed as it relates to a particular individual. So the police conduct their investigation, and they found it reasonable to charge these 6 officers for the death of Johnson, Duncan, and Eccles. In the courtroom, the litigation process is what we call adversarial. The prosecution lays its case, the defense gets the opportunity to cross-examine the witnesses who are brought before the court to prove the case against the individuals. What we see, if we were to get a bit into the facts,
yes,
Mr. Johnson,
by all means,
and perhaps we can touch on the one involving the 6 police officers, which is when we examine those officers, Timrat Sahadeu, Rinaldo Rivero, Glenn Singh, Roger Nicholas, Safraz Juman, and Antonio Ramadin. These officers were on an exercise. Shumba James was a suspect wanted for allegedly in being involved in 2 murders. And they got intel, as we see, intelligence that he would have been on in that Barracktor area on a certain date in July 2011.
Yeah.
The police, having received that intelligence now, knew that they were looking for a B-15 vehicle. They said that when they approached the occupants of the vehicle used, well, they fired at. They discharged their firearms in the direction of the police officers, and the police officer did what was necessary to preserve their life. If they're under gunfire from the persons who are in occupation of the B-15, the vehicle under surveillance, then they return fire, and when the dust settled, a 20-year-old Abigail Johnson, who was the driver, a 27-year-old Alana Duncan, and a 29-year-old Karen Eccles were dead. In other words, the police were in their lawful execution of duty. They weren't there harassing civilians on that particular day in July 2011. They were there on an exercise, and only when fired upon they returned fire. They had, in other words, they didn't kill. That is the plight of the officers. They neutralized a threat that was posed to them. In other words, returning fire wasn't returning fire with an intention to kill anybody. It was returning fire with an intention to stop the onslaught that they were being subject to. Of course, the evidence that came out is there were initially 7 officers arrested and 7 officers charged in October of 2011 for the murder. And what transpired is simply this: the lead investigator, one Raymond Craig, he was able to extract by way of witness statements information that Shumba James was not even in the vehicle. So the guy that they were looking for in this B-15, he was not in the vehicle on the day in question. The police were more or less chasing the wrong vehicle. In other words, innocent civilians in Duncan, Eccles, and Johnson, they were shot at by police officers, with the police carrying the impression that Shumba James, who was the boyfriend of the driver, Alana Johnson, sorry, not Alana Johnson, Abigail Johnson.
Yes.
Shumba James was in the vehicle. So what they were saying is, contrary to the police evidence that these persons were discharging firearms in the direction of the police officers, it could not have been so. Now, what Nicole Clement is a 7th officer. She was she's the center post of the evidence against the other 6 officers. She was also a police officer. She was one of 7 persons charged, but in exchange for her witness evidence against the other 6 officers, she entered into a plea whereby she turned state witness against her colleagues. Nicole Clement offered evidence in the magistrate's court in Princestown, where she gave a certified statement endorsed by a justice of the peace, which reflected that 2 of the occupants of the vehicle, which would have been Duncan and Johnson, they would have been still alive. Sorry, Eccles and Johnson, they would have been still alive when the dust settled after the gunshots were exchanged, as they say.
Yeah.
In other words, after the police fired at them, the Karen Eccles and Abigail Johnson were alive. And what transpired out of that is they were taken to, she was saying, Nicole Clement said that they were taken to a nearby road and they were shot. In other words, they were still alive after the shooting, but the police saw it fit to take them into another place in another vehicle and have them shot and placed in the vehicle. In other words, it was a murder. It's okay to return fire, but once the threat of force being used against you, meaning once the civilians stop firing at the police officers, then the police officers ought to stop returning fire, if that version of the facts were correct. But to now, when the dust settles, see 2 persons still alive in the vehicle, they are now mortally injured, or they are injured, and therefore they ought to be arrested, taken to hospital, and eventually interviewed and due process applied, meaning they have to go to court.
But that didn't happen.
But the officers saw it fit to shoot the individuals. That was the case.
They were shot summarily, as you say.
Right. Johnson gave that evidence in the Princestown Magistrates Court at the preliminary inquiry. Remember, the inquiry is a sufficiency hearing. They were subsequently, the 6 officers were subsequently committed to stand trial before the High Court. When the High Court matter started in November or not, well, in the latter part of 2023, Nicole Clement, the main witness against the 6 officers, who was living for 12 years in witness protection, she refused to offer any evidence against the police officers.
Against anybody, she became. Is that what you call being a? Is that what you call being a hostile witness? She became a hostile witness.
Right. She became a hostile witness. In other words, when you give a witness statement and you renege on the witness statement, you become hostile to your own evidence. In other words, you're recanting the original statement you gave. You went against what you said. In other words, when at one time in the Princess Song Magistrate Court, she was saying that these persons were executed, 2 persons were taken out of the vehicle, taken to another area and shot. By the time she got to the High Court and the trial began, she refused, she went silent and refused to offer evidence at the High Court. Let me put it this way. If you give a statement in the Magistrates Court, that statement is certified by you, then it's declared to be true before a jury, a justice of the peace, and then it's authenticated by the JP as having spoken to the witness swore to him that the statement she gave is true, and that she declared she's very much aware that if there's any untruth here, she could be liable for perjury. And then that process would have ensured that the statement could be admitted into evidence under the Preliminary Inquiry Indictable Offences Act.
To what extent then did that have an effect on the ultimate decision in the case that the police officers walked free?
Well, without that statement, there would have been no evidence to support the theory that the officers executed those 2 individuals. Nicole Clement was part of the team of officers on the day, so she had inside information as to what happened in terms of whether they were actually shot upon and under what circumstances the officers returned fire. As police officers, you cannot discharge your firearm and shoot at individuals unless it is you yourself have been under fire. In other words, you must demonstrate that you use reasonable force to a threat that was posed at your person that was equal to the threat that you faced. In other words, if somebody attacked you with big stones, you ought not to discharge your firearm. But if they're attacking you by discharging their firearm, then you're entitled to use, in like manner, to use your firearm. In other words, reasonable force or self-defense pivots on using force that is needed to neutralize the threat that you are facing. Clement is stating that no one from that B-15, neither Johnson, Duncan, or Eccles, discharged any firearm in their direction. So the case pivot on when the police officers simply execution style firing upon a B-15, only to realize at the end that the man they're really looking for, Shumba James, was not even in the vehicle. So in other words, they can't justify the use of deadly force. And without Johnson's evidence, it was sufficient to cause the officers to be charged. And without Johnson's evidence in the High Court, in other words, at the High Court level now, having given a statement at the magistrate, but that was used in the magistrate's court at the High Court level, that witness, Nicole Clement, ought to have been called, which she was, and she was placed in the box. She affirmed to tell the truth, and then they proceed to cross-examine her, meaning her statement, she has to give a version of the facts as it happened. She had to tell the jury, listen, this is the position. I was a part of the team. We weren't fired upon. The officers fired upon the vehicle execution style, that the use of force was unnecessary. It was not in keeping with the police use of force policy, which speaks to the fact that only when you are under gunfire, you could in turn use gunfire. And therefore, the police followed a pathway of executing individuals in the B-15, not knowing for certain that Shumba James was in the vehicle. In other words, though they had intelligence that he was in the B-15 and it turned out that he was not, that is on them. And this storyline that they were shot upon by the officers that Clement is saying never happened, it adds to the state's case that these individuals were murdered. Now, Nicole Clement, if she had offered evidence in the High Court, at least the jury would have had the benefit of hearing her voice. observing her demeanor when she gives the evidence and being able to draw value from what is being said. But she went silent. She refused to give evidence when brought to court. And what the court had to do is to, the prosecutor, when it is you find yourself in a position where your main witness is refusing to give evidence, what the prosecutor does is she has to make an application to deem her witness hostile, meaning that the witness is refusing to say anything. The witness has gone silent. Sometimes the witness may not go silent, but the witness could simply want to change the story and say, well, actually, I was lying when I said that
but she didn't do that. She just refused to. She just refused to give evidence.
She didn't positively deny her original statement. She just refused to speak. Now, whether her motive for not speaking, no one knows. Remember, she spent 12 years in police custody. She spent 12 years under witness protection in police custody. So it means to say that she was complaining that the agreement and the arrangement she had in the plea bargaining arrangement was that she would offer her evidence and that they would keep her and her daughter under witness protection care. She was protesting about the sanitation of the environment, about the treatment whilst in witness protection, about the place being moldy, about the conditions that she lived under for 12 years being horrendous. And whether in protest for the accommodation afforded to her, she chose to remain silent. No one knows what was the motive is. So it's not that she claimed that her original statement was not true, it's that she just went totally silent and said nothing further. So omission to speak when called upon to give the evidence caused her to be deemed hostile, meaning she's refusing to lend evidence to the state's case and corroborate her original statement.
Okay, and in the way in which we have come to understand it, did that affect the outcome and the decision of the jury in the final analysis?
In the final analysis, without her evidence, the 6 officers walked free. In other words, the very substance of the state's case lay on the foundation of the statement she offered in October 2011. Without her statement, without her evidence, without her witness evidence as to what happened, there was no case. The prosecution's case against the 6 officers collapsed. In other words, the be-all and end-all of the case was Nicole Clements' evidence.
So in your estimation, in the estimation of the ordinary person, was justice done in this matter or not?
Well, the answer to that is justice was done. Right?
Because the process happened the way it should happen.
Bear this in mind. Justice can be done without the verdict being a correct verdict in the context of, all right, let me say that another way.
Right.
Sometimes guilty people are set free and guilty people win their matters before the court. And by so winning your matter, justice is served. Because it means to say that the state did not satisfy the jury beyond reasonable doubt that these individuals were guilty of the offense of which the prosecution claims they were. So in that case, the system worked. The adversarial trial system that we all live and abide by constitutionally in this country, it worked and justice was served. But what is justice? Justice is that a man was allowed, and in this case, 6 officers were allowed due process of law, that the prosecution got an opportunity to state its case, and that the state collapsed and the state was unable to prove beyond reasonable doubt that they were responsible, and therefore they were set free, so justice was done. Now, whether these officers were guilty or not guilty is a different issue, meaning that whether they were the killers of these persons or whether their version of the facts is correct is a different story. Justice is not about the correct version of the facts or the truth. It has nothing to do with the truth. It has everything to do with the evidence. So there's a kaleidoscopic difference between evidence and truth and evidence and guilt. Sometimes the evidence points to innocence, but the truth is reflected in the evidence. In other words, without Nicole Clements' evidence, we saw 6 officers walk. With her evidence, the truth may have come out. Who knows? But it is a fault of this. It is a fault of the individual, the layperson sitting in the armchair back home, to say that these officers were guilty and the guilty walked. The system proved that they were innocent, and the system could fail. the system could fail in terms of it did not provide Nicole Clement with the sort of comfort that she wanted, and did not provide her with the reassurance that her safety after the verdict, if she offered evidence, would be assured. Nicole Clement may have chosen to exercise silence and not offer evidence against the individual because she feared if she has to live in a witness protection system thereafter, the condition she lived even before the trial may only replicate itself after.
Yeah.
So she lost faith and trust in the system, and therefore if her inability to offer evidence was pivoted on the fact that her frustration with the system and the assurances that it offered her, she refused to give evidence. So
and she can't be faulted for that. I mean, when everything is considered, she can't be faulted for that.
Exactly. One could say this way: the officers may have been guilty and may have been responsible for the death, but we don't know because Clement didn't offer evidence and the state wasn't afforded the benefit of being able to hear or being able to pilot its case properly before a jury because Clement refused to offer her evidence. And as a result of that, the case against the officers collapsed and they walked free.
Yeah.
In a courtroom, guilty people walk free because the evidence has failed to materialize in the courtroom, but the evidence was not proven beyond reasonable doubt. That doesn't mean to say that the police officers who conducted the investigation, which is Craig and his investigative team, wasn't correct in asserting that they had the guilty men before the court. It's just they couldn't come up with the evidence to prove the 6 officers were guilty.
All right, and that's the nature of the system. Let's switch now in the time we have remaining on the next question, the Vindra Naipaul Coolman matter, in which 9 young men, was it 9 or 7 young men, again, were on trial for that, and Mr. Khan was the prosecutor in it, and people put a lot of store in the fact that he would win this one, and he didn't.
Right. Now, Vindra Naipaul Coolman, she was abducted at her home in Radix Road in Lange Park on December 19, 2006. It is alleged that she was taken to the La Puerta house in Diego Martin where she was tortured. Her body
dismembered shot, and so on.
Her body dismembered and the remains buried in a shallow grave. Thereafter, a police investigation was conducted. Now, bear in mind that this case, the deceased body, her remains were never recovered. So no one knows. The family didn't get the benefit of closure in the context of having access to her remains to even bury her. The evidence as it came out in the courtroom spoke to she being taken to the La Puerta home and she being tortured, beaten, and then shot by one of the accused, shot in the chest. And thereafter, a chainsaw was used to cut her arms off, a left on her right arm, a left on her right foot. And then her torso was cut into pieces. Her remains were placed in a garbage bag and buried under a galvanized sheet in a backyard. Now, the thing with this case is this. There were witnesses who at her Langeburg residence who would have heard noises outside. And they would have seen 3 men and her screaming from the window of the house. And thereafter, her Naipaul was taken and pushed into a vehicle and taken away. What was left in the wake of that is they found at the car park area in Langeburg where she lives, her glasses, her dentures, and shell casing because a shot was fired. It appears that she was shot by the vehicle on the night in question. Now, the persons in the house couldn't identify who the individuals were because all they know is an altercation is taking place. It's 3 men, a gunshot rang out, and then what they got at the end of the day, see a car speeding off with her, she being abducted. One of the individuals who turned state witness, who offered evidence, he indicated that he witnessed on the 3 days after Christmas that she was shot in La Puerta and the body dismembered. Now, the evidence that came out in the courtroom was that she was placed on a pool table. Duct tape was placed around her hands and side, and she was shot and then dismembered. When the scientific evidence was applied, meaning the CSI officers come to a crime scene, what they do is they investigate. They look at the crime scene. They use luminol to try to ascertain whether the red substance they're seeing is indeed blood. They also wear personal protective equipment, which is those white coveralls, to ensure that they don't contaminate the crime scene. So one of the witnesses led them back to the police investigators, back to the La Puerta de Gomatin house. And then they have to now deconstruct the crime scene. And in deconstructed, they have to reenact what may have happened. So there is no CCTV footage that captures what happened in that house. There's no CCTV footage that captured what transpired in the Lange Park car park when she was grabbed. And all the case pivot around the evidence of an individual who states that she was dismembered on the pool table. When it is crime scene officers examine the house, what they're saying is that the room was so small that if it is somebody was cut open, a body was cut open with a chainsaw, blood would have spouted, splurted, sputtered in many directions, and the room ought to have extracts of blood samples and stains in and around the table where she was dismembered and on the table. The science reflected that that version of the facts that the prosecution was offering in the courtroom could not be, because though they say that they got blood on the duct tape, there was no scientific evidence that established that. Though they say they got blood on the table, what they're saying is that there was no evidence, scientific evidence, that there was blood on the table. So in other words, the state's witness, the science disproved the story. In other words, the story that Gloucester, the person who offered evidence on behalf of the state, his storyline of that she was dismembered on the table doesn't tie in with the science. In other words, if she was killed on that table, it doesn't, when the crime scene officers looked at the table and tried to examine whether there were blood sample remains, they say, well, we're not seeing any blood sample remains. Let us be practical. If it is we get pricked with a pin on our thumb, or if it is we walk on a broken bottle in the road, or if somebody is shot with a broken bottle, and at the point of impact, blood flows. And you could imagine the amount of blood that is flowing that would soak your t-shirt or your shirt. Can you imagine now if it is you have 6 pints of blood in a human body and you're cutting that open, and 6 pints of blood is exuding from that body mass? It's impossible to believe that blood wouldn't spill on the table. It wouldn't spill in the surroundings. So what they're saying is that the science didn't support Gloucester, the state's witness evidence. So therefore, it is unbelievable that his version of the facts took place. Now, nobody's saying that Vindra Nigel Kuhlman wasn't murdered. What they're saying is that the prosecution's case that these individuals were responsible is suspect, does not stand up to scrutiny, because science disproved the main witness theory that she was cut up on a table and her remains were placed in bags and she was buried outside. Another thing is this: he said she was buried in La Puerta in a dirt area under a galvanized sheet. When the police officers went there and they exhumed the area, they dig up the land, the soil under the galvanized sheet in the vicinity, none of her remains were found. So if it is the man is saying her body was cut up, she was placed in a garbage bag, her remains were put inside it, were dug and buried in a hole, none of that was corroborated.
Right, and that's the essence of the justice system. And so in this case, from how you go back over the facts there, I think for most people it is easier to see how the justice process worked in that one to the benefit of the accused.
Yes. And bear in mind, the difference in the Vindra Nigel case is that the evidence was circumstantial, and the state depended not just on the circumstantial evidence, but the scientific evidence. There was no IC witness to see somebody say they witnessed anything. Remember, in the police murders, the Moruga murders of 2011, there was a Nicole Clement who turned state witness, who said she was there and she saw, and she was part of the experience. In this matter involving the accused in the Vindra Kuhlman Naipaul matter, there was no witness who, the witness who said that they were there and they saw. Yeah. The science disproved what he was saying. In other words, his story could not be proven beyond reasonable doubt because some of the analogy that he was making, some of the things he claimed to have witnessed, was proven to be scientifically impossible. So it's almost as if, yes, this is your version of facts that she was dismembered on a pool table and buried in the backyard, but the police investigation didn't support what he claimed to have witnessed, and therefore the state's case collapsed on that, and the individuals walked free.
Yeah. All right, my friend. Thank you very much. Once again, you've been a great help in trying to get us to understand this issue about the prominence of justice, regardless of what happens. That's our broadcast for this edition of the program.
Thank you for your time. Enjoy it.
Thank you very much, Farid Ali. This has been 10 Questions on this edition. I'm Andy Johnson. Thanks for watching, and we'll see you next time.
WESN